So I think we'll wait for Emily to reappear and to have her screen share reappear, and then we will get started. It is right at 3:15 and we have a lot to get through. So I'm going to pass it over to Emily. My name is Jessica, but Emily will introduce us both in just a moment.
Good afternoon. Welcome to this afternoon session. My name is Emily McNee and I'm here with my colleague Jessica Bradley virtually, and we're here to talk to you today about some of the biggest questions facing employers in 2020 and 2021. And since we are in the middle of a pandemic, presentation wouldn't be complete without talking about COVID-19, so we'll cover some of those hot button issues as well. Our contact information is here. If you have any questions after the presentation, feel free to reach out. So a couple of advisory comments to kick us off. We won't cover anything and everything about employment law today. And in terms of COVID-19, we don't know everything because the situation is changing on a daily basis. And then finally, as always, this webinar does not substitute for the advice of counsel. So we're talking to you about employment law today because startups and small businesses are not immune from employment laws, and not being in compliance with those laws has the potential to really jeopardize your business and derail things. And so you want to make sure that you're working from a legally compliant framework from the get-go, and it'll save you, money and potential headache down the road. So we've got 10 questions here that we'll cover in case you need sort of a roadmap to go back to later. And we'll start with what do you need to know when you're using social media to engage in hiring? So we know that many companies are using social media and looking up candidates on social media as part of their hiring process. And it's been a successful tool for people to refer potential candidates or find potential candidates for employment. Some of the questions that we frequently get from businesses are, what can I look at that's out there online? Can I Google someone? Should I? And depending on how the candidate is controlling their social media privacy settings, you can really learn a lot of information about somebody online. I think we've all, Googled ourselves and found lots of information out there. Some of it might be, about you, some of it might not be, but certainly a lot of stuff out there that can influence someone's decision for hiring. And there's sort of a double-edged sword when it comes to social media. So you can find some information that's really useful to you if you're making a hiring decision. So you might find photographs that are inappropriate, or content that involves, drugs or unlawful conduct. And so that's the type of information you might want to know before making a hiring decision. On the other hand, you can also inadvertently learn some information that usually you go out of your way to avoid. So for example, a person's religion, their age, their national origin, what types of past litigation they've been involved with, their genetic information or their marital status. And this type of information you might just come across on someone's Facebook page or social media. And it can, cause some problems down the road. So for example, you might find some of this, too much information about a candidate. So started chemo yesterday, but feeling good so far. Or my husband has cancer and we're going to beat it. So information about somebody's medical condition. And if, looking at this information is a factor in an employment decision for whether to hire somebody, and a, decision is made to not hire them because of some of this information, they might have the possibility to bring a claim against you for some type of discrimination. Employers also have duties with respect to hiring, retention, and supervision, and can be liable when they hire an employee who then harms others and the employer, either knew or should have known of that person's, likelihood, propensity to cause that type of harm. So while you may have, good intentions in looking at social media, some of these, double-edged sword factors may cause you to reevaluate, whether you really want to go forward with Googling that person or checking up on them on Facebook. Once you've decided that you're going to make a hire, you need to decide whether that person who's going to provide services to your business is going to be classified as an independent contractor or as an employee. So an independent contractor is someone who provides, services to an entity, typically as specified in a contract or a verbal agreement. And there are a number of different advantages if you have someone in a contractor relationship as opposed to an employee. So typically that person's getting paid on a 1099 as opposed to a W-2, and you're not required to have, workers' compensation insurance or pay into unemployment insurance for that person. No taxes are going to get deducted from that pay. And you have a lot of employment laws, statutory employment laws that you don't need to comply with, for example, minimum wage, overtime, and you avoid some other, potential tort liability. But as the business, you don't get to necessarily just decide which classification you prefer. There are a number of different, factors that go into whether someone is a contractor versus an employee. And the risk of making a misstep and getting it wrong involves some significant liability for potential overtime claims or other, wage and tax liability. And so there are a number of different tests to assess whether somebody is an employee versus a contractor. Typically, when you think of a contractor, it's someone who has the ability and independence really to go out and perform services for more than one business. They have a particular skill that they're, being asked to utilize. They supply their own tools. They decide when they perform the work. These are some of the factors that are looked at when assessing whether someone's a contractor versus an employee. So it's something that you want to think about closely and, consult with your legal counsel about whether the person should be classified as a contractor or an employee. And we do recommend that if the person is a contractor, that you put together an agreement with them that's going to explain that relationship, and then you want to make sure you continue to manage that relationship going forward in a way that's going to be legally defensible. So if you have somebody who you're saying, come to our office or our building, 8 to 5, Monday through Friday, and here's what you're going to do each day. Those are the types of, directives that you typically give to an employee. So if you've got somebody set up as a contractor, you need to make sure you're managing that relationship consistently going forward. Another employment classification decision that you need to make a decision about is exempt versus non-exempt. So when we talk about exemptions, we're talking about whether someone is exempt from requirements to be paid overtime, typically, and there are sort of two factors that come into play when making that decision. So first, there is a salary threshold. Right now, it's $35,568. And so if a person's not being paid at that level or above, then they're going to be a non-exempt employee, and they're going to be subject to all of those minimum wage and overtime requirements. If you have someone who does meet that threshold, then there are certain duties that apply as well. So if someone is going to be considered exempt from overtime, they've got to meet both that salary test and certain duties. And there are a number of different exemptions that have different tests that go along with them. And so before you decide whether someone is exempt or non-exempt, you want to make sure you've thought through all of those factors. And it's something you need to decide about at the outset. So we recommend that your job posting or your job description should reflect whether or not the position is exempt. And your offer letter, when you make an offer of employment to that person, should indicate whether they are going to be starting as an exempt or a non-exempt worker. And the reasons for doing all of this at the outset are, you can have potential liability as soon as that person begins performing work. If you've put them in an exempt job classification and it turns out you weren't, correct about that, and they have been, for example, working all kinds of overtime, then you've got some possible liability there. So I'll turn it over to Jessica to talk about opening or reopening.
So we've talked a little bit about classification issues and how we get through the hiring process into getting that employee in the door. And now we're going to talk a little bit about the impacts of COVID-19 on the workplaces that we're seeing right now. And the first question is, what steps must employers take before they can open or before they can reopen? And in Minnesota, like most other states, there's a lot of executive orders that really dictate when and how an employer may reopen during the pandemic. In Minnesota, you have to issue a COVID prevention, preparedness, and response plan. And so, like I was saying, this is different in every jurisdiction. Right now, we're just talking about Minnesota, but all states are going to have something that's kind of like this. And most states right now also have mandatory masking obligations, which kind of complicate how an employer can bring their employees back and what they can tell the employees are expected of them for their own protection and for the protection of the other employees and the public. We can switch the slides. And so what is a preparedness plan in Minnesota? And right now that is policies and procedures that have people coming in and identifying whether they're suffering from any potential symptoms of COVID-19 and screening out those employees who may be infected with the virus. It also calls for employers to take certain steps to make sure that the workplace is a safe and healthy environment for all of the employees. So that might be social distancing, hygiene practices, masking, which is mandatory in Minnesota right now, workplace cleaning and disinfecting, ventilation system updates, drop off and pickup and delivery procedures, and also, thinking about how people get into and out of the workplace. Like, are they coming up an elevator? How are you going to facilitate people doing so in a safe and healthy manner? For client-facing businesses, there's also some concerns about customer interaction and making sure that interaction is safe for both the customers and the employees that are working. So when we talk about recommendations and considerations, some of the things that people, particularly in Minnesota, are thinking about is, can the work be done from home or can it be done remotely? That means that you don't have to worry about isolating your employees in a workplace if they're already isolating at home. And Minnesota is one of those states that says, if you can work from home, you must. So a lot of people are considering, can my workforce really go remote? Some of the other considerations are engineering controls, administrative controls, procedural controls, personal protective equipment, which essentially is the mask in some of these situations, but in healthcare settings, that means something completely different. So be aware of the difference in that definition. And developing plans for how you're going to keep employees out of work that are sick, what you're going to do to support those employees, and how you're going to make sure that when they're doing the screening process, they're encouraged to comply and accurately screen their symptoms. The next thing that we're going to talk about is, what can you do if your employee refuses to work or refuses to wear a mask? And so this is a very common question. So we started out with the COVID period where people were really gung-ho and like, oh, we're gonna work from home, we're gonna do what's safe. And now as we kind of get that COVID fatigue, we're starting to see people trickle into the workplace and realize that we need to figure out a balance of how we can get the work done but still ensure people are safe. And a lot of that has to do with the preparedness plan, but some of that does have to do with masking and getting your employees to feel safe and coming to work. A lot of employees are now concerned about the safety of returning to work. And a huge part of that is just making sure that the employee is aware that you have safety procedures in place and that you're going to do everything that you can to make sure that they feel healthy and safe at work. Even after that, we still see some employees citing some objections. And when you hear objections to returning to work or refusing to wear a mask, I think it's very important to ask why the person is making that objection. The objection may come from a protected reason or for a protected reason. For example, if a person is part of has a health condition or is part of a class of people who are particularly susceptible to the virus, they may have a very legitimate medical reason for trying to quarantine at home rather than exposing themselves to something at work. And in that case, it's up to the employer, once anything like that is raised, a protected reason, a medical condition, is the obligation of the employer to engage in the interactive process to see if a reasonable accommodation can be provided. And we talk about, a reasonable accommodation because of some of the discrimination cases and the discrimination claims that Emily was talking about earlier. If a person raises a serious health condition, they fall into a protected class, and if you do refuse to accommodate them or engage in the interactive process to discuss what a reasonable accommodation could be, then you expose yourself to some risk of potential litigation down the road. And we'll talk about the potential claims that we're seeing from COVID-19 a little bit in the future. And when you think about accommodations, we really see a variety of accommodations that can be provided. For example, a lot of people are offering a temporary accommodation of work from home. Or some other employers are offering staggered schedules for people so that they aren't interacting with other people, a slight change in work duties or interaction at work so the person no longer has to interact with other people at work to make sure that they feel safe and that their health condition is accommodated in the best way possible. So now that we talked about refusing to come to work, what about if an employee refuses to wear a mask? So the first thing that you have to do is check your relevant masking orders. As I mentioned at the beginning of my section of this presentation, states have issued a number of orders, and all of the orders are slightly different, and those orders have been amended. Certain parts have not been amended, certain parts are still in effect. So it's very important to stay on top of what's actually happening in your state. So when you check your relevant masking orders, what you're looking for is, do these masking orders contain any prohibitions on what I'm allowed to ask my employee when they refuse to wear a mask? And there are some states that say if an employee refuses to wear a mask, that's the end of it. You can't really ask a lot of questions, or you can only ask a few questions. You can't ask, about the condition that the employee might be raising. But here, again, it's important to engage in the interactive process and contemplate reasonable accommodations. In the masking case, I think we see a lot of, there's a lot of alternatives out there. And we see a lot of alternatives continuing to flow to the marketplace. So there might be face shields, there might be a plastic barrier that could be erected, there might be a slight change in the way that the person is expected to do work. But it's important to engage in that process. The next consideration that has been completely exposed due to the pandemic is, what do we need to consider about employees working from home? And so now that a vast majority of the workplace is telecommuting, we have to start thinking about the issues that might arise when people are telecommuting. Like I said before, in Minnesota, if you can work from home, you must under our current executive order. When we think about some of the big issues with telecommuting and the considerations that employees have to take, one of the first things is, how do we handle tax reimbursements or expenses, or taxes and expenses? And in Minnesota, we have a requirement here that employers are required to reimburse employees for their expenses, including equipment and consumable supplies. So there's some debate on what consumable supplies means, but that means that you generally have to reimburse your employees for the expenses that they're incurring while working from home. And that's going to be different state from state. So the federal standard is you don't have to reimburse unless the cost or the expense would bring the employee below the minimum wage that Emily was talking about for the non-exempt employees. but every state's going to be a little bit different. And for example, if you happen to have an employee in California, it's very, very clear that you have to reimburse every expense, including like internet, Wi-Fi, things like that. Next question is, how do you handle taxes for teleworking? Say your employee is now working in Wisconsin. What taxes do you pay? All but a handful of states impose income taxes, but those taxes are connected on non-residents. So all but a handful of states impose income tax on non-residents, but days worked or dollars earning, those are different for thresholds. So in some cases, you might be required to withhold from multiple states. There are some other issues that we see with home office, and I think the biggest one is on the wage and hour side that Emily was talking about before. So for non-exempt staff, you're responsible for making sure that those people track their hours and that they track their hours accurately, take appropriate breaks, and that they're compensated for all the overtime that they're working. So you have to develop a system if your employees are at work to make sure that all of those things happen and that your employees are paid appropriately. For exempt and non-exempt, you still have to consider the reimbursement expenses that we talked about before. And then with employees working from home, you also have to consider all of the things that you would consider when you're creating a workplace, a general workplace for your employees. Is it safe? Are the employees being compensated, or are you taking care of your workers' compensation insurance? So that also covers them if a workplace injury is incurred during the home. Are you making sure that your expectations are clear so that your employees have a dedicated space to work, that they won't be interrupted? It's more complicated than you would think, as most things that attorneys talk about. And so it's a good idea to come up with a set plan and to explain that to your employees when you're dispatching them to be telecommuters. So now we get to what other wage and hour issues should we be concerned about? And we're going to jump right into Minneapolis in particular. So Minneapolis has its own minimum wage ordinance, which raised the wage to $15 an hour by July 1st, 2020. So that's already occurred for large employers. And by July 1st, 2024 for smaller employers. And we also are seeing a similar wage increase in St. Paul. So that is bringing everybody to $15 for large businesses by 2022. One of the big things that we see in Minnesota and in many other states is this push against wage theft. And so that means that that employers are now required to provide a detailed statement of an employee's wages and how much they're being paid, and includes specific information that shows, exactly what they're being paid and breaks it down into commissions and other things like that. It also created criminal penalties, which is kind of uncommon in employment issues. And Minneapolis, not to be left out, created their own version of this and require an even more detailed statement that also tracks Minneapolis sick and safe leave. So we can go on to what type of leave obligations do employers have during the pandemic? And I'm going to hand this back over to Emily.
And I'll just add on the wage theft piece, we do have a number of templates that we've developed for employers that comply with the state and city wage theft requirements. So if you're interested in seeing a copy of those, we're happy to send it to you complimentary. Just shoot us an email and we'll get that to you. So in terms of leave obligations that you might have during the pandemic, the primary one is the FFCRA, or the Families First Coronavirus Response Act. And this law covers employers with less than 500 employees, and it requires you to provide two types of leave. One is emergency paid sick leave, and two is expanded family and medical leave under certain circumstances. And this is paid leave that gets provided, but you can get a dollar for dollar refundable tax credit for any paid leave that does get provided. Right now, it's in effect through the end of the year. So if an employee is unable to work or to telework, so work from home, because of one of these 6 reasons, then they're eligible for paid sick leave. So someone gets subject to a quarantine or isolation order, or a healthcare provider advises them that they should self-quarantine. They're experiencing symptoms of COVID, sort of all of these reasons that you would expect. We don't want someone working in the physical workplace, and they might be so sick that they're unable to perform their work from home. They're going to be eligible for this paid sick leave. It's up to 80 hours of paid sick leave for any employee. And there's a little bit of a difference. So for these first 3 qualifying reasons, it's at their full rate of pay. For the last 3 reasons, it's at 2/3 of their rate of pay. And there are dollar caps on that as well. And this applies for any employee. So no, waiting period that you might have with an ordinary sick leave or PTO policy. And then in addition, the expanded family medical leave provides leave for employees who need to take time to care for a child under certain circumstances when schools are closed. But the sick leave is the one that we're seeing having the biggest impact. In addition to the FFCRA sick leave, we've got local paid sick and safe time ordinances here in Minnesota, in Minneapolis, St. Paul, and Duluth. We've also seen certain states start to enact what we call mini FFCRA leaves. So dealing with the COVID pandemic at the state and local level. Right now, that's mostly in California, and we don't have a Minnesota law on that issue. And then if you have more than 50 employees within a 75-mile radius, your employees may also still be eligible for traditional FMLA for a qualifying reason if they meet the eligibility criteria. So if someone has their own serious health condition, they may be eligible for additional leave. Next, we'll talk about how the labor and social justice movements have impacted employers. So we've seen lately a rise in organizing activity by unions under the National Labor Relations Act. And so labor unions have really been inundated with calls for help from workers. Workers are fearful of contracting the virus, and there's a lot of unionization going on right now. So you've seen strikes, you've seen walkouts, we've read about it in the news as workers are demanding different protections in the workplace. And many of these workers who are taking action are in unions, but others have done so on their own. And we're seeing the unions really line up to help engage with those workers and their employers. And it's important to keep in mind that as you think about this union activity and the National Labor Relations Act, you might be thinking, I don't have a union, I don't have an organized workforce, but it applies to all employees, whether unionized or not. So this act gives employees the right to self-organize, to join unions, to bargain collectively, and most importantly, to engage in other concerted activities about terms and conditions of employment. And so it's something to keep in mind if you have, for example, increased activity in your workforce about social justice issues. The strike for Black Lives, for example, we're seeing as we get closer to the election, a lot of political speech in the workplace. And so you need to keep in mind as an employer that before you sort of swing one direction and prohibit, one form of speech that, maybe isn't in line with your values or your politics, that the NLRA gives employees certain rights in the workplace. So you want to make sure that you approach those issues consistently. And thinking about what other issues could arise, I'll turn it back to Jessica to talk about what types of litigation we're seeing.
So what employment litigation issues will likely arise during the return to work era? And I know that going into COVID, a lot of experts were predicting that there would be a huge surge of lawsuits related to COVID, related to the layoffs that came at the beginning when states did large-scale shutdowns. And I'd say that we're starting to see kind of the crest or maybe the beginning of that wave come to be. Right now, we are seeing some discrimination, workplace safety violations, retaliation, unpaid overtime claims that are starting to bubble to the surface. And there will most certainly be a lot more of those issues. Some of the claims that we expect to see going forward are more discrimination, retaliation, failure to accommodate, retaliation for taking a leave of absence related to COVID or related to the FFCRA or FMLA leave requests are also probably going to be approaching quickly. I myself have already received several lawsuits, which I think is a little bit unusual, related to retaliation for safety concerns. And I say that because there are some administrative processes that lawsuits often go through, or claims often go through before they get to a lawsuit, but they're already here. We're already seeing a lot of the filings in the litigation. And then, of course, as Emily has mentioned, there's also going to be some unfair labor practices charges probably outstanding as well. So we can expect a lot more coming. So you should stay vigilant, make sure that you're communicating with your employees, you're following your EEO practices and guidelines, and you're doing your best to really comply with the changing landscape. And I know that it's very difficult, but everyone just needs to try, like, buckle down and kind of ride out the wave and do their best to get through the pandemic together. So now we are over our time, but I wanted to let everybody know that if you do have any questions, you can feel free to contact Emily or I. We have lots of tools in Littler's toolbox that can help most employers with their problems. And one such tool is the Accelerator, which is designed specifically for small businesses and entrepreneurs that give you just the basics. It's a low-cost product that gives you kind of the forms and tools and guidebooks that you might need to just navigate your way through the employment process. And so I really appreciate you jumping in and listening to our presentation, and feel free to contact either of us with any questions, and have a great afternoon.
And if anyone has questions now, I think we've got a minute or two. If you have anything you'd like to cover, we're happy to talk about it with you.
If anyone actually wants to expose themselves on screen, that would be great too. I enjoy seeing other people. It's been a while, but I do.
Well, I think we will jump off here, but if you have further questions as you get your business set up, or as you get those first, group of employees hired, or once they're hired and onboarded, managing any of those issues, we'd be happy to work with you if you have any employment law questions. We really deal with everything from anything touching the employment relationship, from pay to classification to discrimination claims, really everything that runs the gamut. So we're happy to be a resource for you.